All right, we are now live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I am lucky, and you are lucky, because I am joined today by two outstanding colleagues, Justices Singh and Hand. We will be hearing 5 cases this morning. We are hearing the cases by teleconference rather than in person due to the ongoing pandemic. However, the rules are the same. It's 15 minutes per side with no rebuttal. The first case we'll hear this morning is number 20-194, Commonwealth versus Lebre. And we will hear first from Attorney McDermott.
Good morning. May it please the court, my name is Diana Cowie McDermott and I represent the defendant. The defendant was charged with operating under the influence, second offense out of Belcher District Court. There were no stipulations, no field sobriety tests, and no breath tests. The Commonwealth's case rested on the police officer's testimony. At issue on appeal are the elements of operation and under the influence. The police officer testified that when he arrived at approximately 6 p.m. at the Dunkin' Donuts parking lot, he found the defendant in a car behind the steering wheel, asleep, and the car was running. The keys were in the ignition. The defendant provided testimony at trial that the car was a keyless ignition. The car required a key fob, and in order to start the engine, one had to press a button called Start Stop Engine. Of course, in the Commonwealth will prove operation with evidence that an engine has started, or the Commonwealth may prove operation when the operator has made use of the power provided by the engine.
So I'm sorry, but why can't the jury find, based on what you've just said, either or both of those? The car is running, blocking an entry to the Dunkin' Donuts. There's someone in the driver's seat. Isn't it a reasonable inference that they operated the vehicle to get it there? It wasn't born there. And then even though it's a keyless ignition, that can be a mistake, the car is running. So it is operating while they are sitting in it. I don't really understand. I mean, I appreciate you have to have an argument, but why couldn't the jury find either or both of those?
Thank you, Your Honor. It's impossible to find that the car was operating because the Commonwealth's evidence is that the car was running. And to support that, the Commonwealth points to the fact that the key was in the ignition. I'm sorry, there is testimony the car was running with the key in the ignition. But that doesn't mean that the officer concluded it was running only upon seeing the key. It was sitting, blocking an entrance to a parking lot, and you can see if a car is running or not running if you look. Running is insufficient. There must be more. I'm sorry?
Go on.
Running is insufficient. It is impossible to say the car was running when this is a keyless entry.
It's not impossible to say the car was running. You could see exhaust leaving the exhaust pipe, right?
Yes, Your Honor. And
all day long, we look at cars and we say, without looking inside them, oh, that car that's idling there is running.
There must be proof of running. In Commonwealth v. Colby, one could infer that the defendant was operating. There was proof that the defendant was behind the wheel, asleep. The court found most significantly the engine was running and the lights were on. In Commonwealth v. Eckert, the the court found that when a police officer testified that the car was running because he heard the engine, one could infer operation. All we have in this case is a police officer testifying that the car was running.
You're saying that it was simply a conclusion, the car was running, and that conclusion needed to be supported by why the officer thought the car was running.
Correct.
So testimony that simply the car was running is insufficient.
Correct.
Okay, let's take running out of the picture. Let's say the car wasn't running. Okay?
Yes.
She's in a car blocking the entry to this establishment, and she's in the driver's seat passed out. Let's say the car wasn't running. A jury could not infer that she had driven that car to that location?
One could infer, if there is proof that the operator has made use of power of the engine, such as turning on the radio, turning on the headlights, turning on the heat. The Commonwealth requires proof that the defendant made use of the power of the engine. It is
Can I ask you a question?
Yes.
What is your hypothesis for how the car came to be blocking the driveway? It's not parked, it's blocking a driveway. How did it get there? Is the hypothesis that it was pushed?
Well, as I say, no. I refer back to Colby, where one can infer operation. And that is in a situation where there is proof that the defendant is behind a wheel, but there is the proof that the engine was running and the lights are on. And that goes to the element that the operator made use of the power of the engine. And that's
how did the car, in your alternative hypothesis, how did the car get to where it is? Someone else drove it, they switched while it was running, and it doesn't have to be, even proof beyond a reasonable doubt doesn't have to exclude every bizarre and remote possibility. How, aside from it being operated, how would it get from a parking space to blocking a driveway?
Yes, Your Honor. And there are several cases where we do not have a witness who sees the defendant driving. So there are cases when defendants are found behind a steering wheel, asleep or slumped over. But in all those cases, there is evidence that the operator has made use of the power provided by the engine. There must be more than a defendant showing up in a car behind a wheel. There must be more. To say that it's the words running is not enough. There must be proof that the operator has engaged the power of the car, such as radio is on, the heat's on, the engine is on. And
how is the radio operating different than the car's running?
Because to say that the radio is on, one can infer operation, that the operator inserted a key and turned on the electricity.
Why do you have to insert a key? Does that mean that in a push button car, there's never operation?
It was a little bit
in a car that uses a key fob?
You're breaking up.
Yeah.
Can you try again?
Sure. Does that mean that in a push button operation car, like the one at issue here, there can never be operation?
In a push button car, there could be operation, and there would have to be proof that the button was pushed to start the engine. That goes to running. Doesn't running...
Wait. So it's not sufficient for someone to observe the car and say that the car is running? Someone needs to observe someone pushing the button?
First of all, none of this evidence came in at trial. So what did come in at trial was, in order to start a car that has a key fob and is keyless, in order to start that engine, One must have a key fob in his hand and one must push a button. That will start the engine. That was the evidence at trial. To go back to Your Honor's question, engine running suggests that the engine is running. And in Eckert, the court found that one can infer the car was running when there was testimony that the officer heard the engine running. That is the difference. There is something other than the words, the car's running. That is insufficient.
You're saying that there was insufficient foundation for that conclusion that the car was running.
Correct, Your Honor.
All right, was there an objection to that effect?
There was none. In McGillivray, there the defendant was found slumped over the wheel. The key was in the ignition. The electricity was turned on. The engine was not turned on. The court found operation because there was the electricity turned on, which goes to the element of making use of the power provided by the engine. As to the Commonwealth's brief, they rest exclusively on the fact that she's sitting in the car and the car's running. And they rely on a footnote in McGillivray where it is reasonable to infer operation when the engine is running. But again, that case relies on Eckert, which requires proof that the officer heard the engine running.
All right. I mean, we'll have to look at the case. I'm looking at Colby. Circumstantial evidence can support a finding of operation. And I think we understand your argument, although the suggestion that it has to be the same exact circumstantial proof as in these other cases is not well supported. Maybe you should move to your next argument.
Yes, Your Honor. The officer, thank you, Your Honor. The officer appeared at the scene following a 911 call that a female was unconscious in her car behind the wheel. The officer testified at trial that the defendant's condition was consistent with being ill or sleepy. He opined that she was under the offense. I apologize for that. He opined that she was under the influence, so he called an ambulance. He noted that her movements were very slow, lethargic. However, she was able to produce all documents that he requested.
She couldn't walk. She couldn't walk. There were open bottles of liquor in the car and she smelled of alcohol. How much more do we need here? Does the jury need for it to be sufficient? I'm not saying compelled, but.
Yes, Your Honor. Well, for the officer, he found that her condition was consistent with being ill and sleepy.
And also
but he reached a different opinion. His opinion was that she wasn't ill or sleepy. His opinion was she was drunk.
He testified on cross-examination that her condition was consistent with being.
Yes, you said that before, but his opinion, based presumably on the smell of alcohol and the empty and not empty bottles of liquor scattered around her, was that she was not ill or sleepy, but that she was drunk. That's why he called an ambulance.
I would respectfully direct the court's attention to his testimony. And that is that he had a conversation with her and there was a moderate odor of alcohol. She was slow and lethargic. He couldn't decide if she was under the influence.
But the jury did.
Yes, Your Honor. Relating to the officer's testimony, he provided impermissible lay opinion. He testified that the defendant was, quote, operating under the influence of alcohol. Of course, under Canty, one cannot testify that one is operating under the influence. This the Commonwealth concedes. The officer was permitted to offer testimony that she was under the influence because that goes to one's sobriety. But in this case, he testified that she was, quote, operating under the influence. And of course, this goes to the ultimate issue.
But it didn't draw any objection, did it?
It did not, Your Honor. It did not, Your Honor. The Commonwealth says that this was, that the evidence against the defendant was overwhelming, compelling, and therefore this is really irrelevant. However, we do not have strong signs of intoxication. There was one case, and I can't recall the name right now, but there was multiple field sobriety tests done. A half a bottle of alcohol was found in the car. The defendant admitted to driving. That's overwhelming. I think here, when we have a police officer who opined that her condition was consistent with being sleepy and ill, we have a police officer who said there were 3 nips in the car. All of them were empty except for one. And then he testified, well, there may have been 4 or 5 nips. All of them were empty except one. And then he testified, well, I can't recall how many nips were in the car. That we fall drastically short of the compelling evidence that the Commonwealth is suggesting. The jury also came back with a question asking for operation to be redefined. For these reasons, I would respectfully ask the court to find that the defendant's motion for required finding not guilty should have been allowed.
Thank you very much, Attorney McDermott.
Thank you.
I think we understand your argument. We also have your brief. We will hear now from Attorney Russo.
Morning, Your Honors. My name is Matt Russo. I represent the Commonwealth in the case before the court this morning. I was also the trial attorney for the Commonwealth in this case in the trial court. I'm asking the court to affirm the trial court judge's ruling denying the defendant's motion for required finding of not guilty based on the sufficiency of the evidence. I would suggest that the evidence in the light most favorable to the Commonwealth, notwithstanding the evidence presented by the defendant, was sufficient to permit the jury to infer the existence of the essential elements of the crime charge under the LABRIE standard. First, Your Honors, in addressing the element of operation, I would suggest, as Your Honors pointed out, while my main testimony presented by Officer Brown was that the car was running, I would first suggest that running alone is enough for the jury to make an inference of operation. We have, just because some cases point to the fact that lights are on or music is on or a car is warm to the touch, it's a case-by-case basis. Not every car that's running is going to have those elements. In here, what Officer Brown observed was a vehicle that he testified was running. However, while I believe that is sufficient enough, I think you can look to other things to support that observation by him to support an inference of operation. First, as Your Honors pointed out, the vehicle was parked in a very strange location. It was blocking the entrance and exit to the Dunkin' Donuts. It was actually impeding people from coming and going to the business. It wasn't parked in a parking spot or a driveway. It wasn't parked properly. And so I would suggest that that bit of evidence together with the fact that Officer Brown testified the car was running, as well as the fact that later in the case, once Miss Lebre was placed in the ambulance, he also testified he went back to the car to turn it off, which I would suggest is another subtle bit of evidence that the jury could have relied on in order to make the decision, the finding that the defendant operated the vehicle. I'd also suggest that just because he testified that the keys were in the ignition, under the Lattimore standard, under sufficiency of the evidence standard, the officers were not appealing the officer's credibility. The jury is free to believe one bit of evidence and not believe another part of the evidence, as the trial court judge instructed them on how to weigh evidence and what decisions to make in listening to and deciding on officer credibility. So I would suggest that the Commonwealth has presented enough evidence to support a finding of operation. In terms of the intoxication element, Your Honor, so I would suggest that while Officer Brown on cross-examination admitted or adopted the fact that this could be an alternative, the alternative explanation here could have been, these factors are consistent, I should say, consistent with somebody being ill. It's important to note that when Officer Brown spoke to Ms. Lebre, he asked her directly, was there anything medically going on? And she said no. There's also other strong factors that can certainly lead the jury to have found that she was intoxicated, such as the open bottles of alcohol found inside the car, as well as a moderate odor of alcohol on her breath. She was also slow, lethargic. She was having trouble keeping her eyes open to communicate with Officer Brown. When she got out of the vehicle, she couldn't walk or stand on her own to go to the ambulance. And so all of these factors that Officer Brown testified to could certainly support a finding that the jury could find that the defendant was impaired. In terms of Officer Brown's testimony, that the officer was, or that Ms. Lebre was operating her motor vehicle under the influence of alcohol, as the Commonwealth notes in their brief, we would concede that under Canty that sort of testimony is not permissible. He should not have phrased it that way. However, that testimony did not draw any objection from the defendant at the time. And so I would suggest before the court that the standard of review that we're looking, that we should look at this error under is that did it create a substantial risk of a miscarriage of justice? Did it materially influence the guilty verdict? And I would suggest no. And some of the factors that the court has looked to in making this decision is the strength of the Commonwealth's case, the nature of the error, and the significance of the error at trial. I would suggest that this is a strong case for the Commonwealth based on the factors I just kind of went through in terms of operation and intoxication. All of those factors: alcohol in the car, the odor of alcohol in her breath, her physical indicators, all of those factors I would suggest lead this to being a strong case for the Commonwealth. I would also suggest the nature of the error was brief. Really, Your Honors, if you take a look at what Officer Brown says, he says that that Ms. Lebre was operating under the influence of alcohol. He then goes on to list those sort of factors, why he made that opinion, why he formed that opinion, and then at the end says, again, I formed the opinion that she was under the influence of alcohol, which is admissible. So really, in looking at Officer Brown's testimony under Canty, the only thing he really said, it comes down to one word. He said operating. If you take operating out, everything else he says is admissible. So I would suggest that in the course of the trial, that's a fairly brief, insignificant error. I would suggest the case law, specifically Commonwealth v. Saulnier, where there was a very similar set of circumstances, similar testimony by the officer that also did not draw an objection from the defense. The officer in that case said that the defendant's ability to operate safely was impaired. And that was, again, in response, like in this case, to a question about whether or not the officer formed an opinion to the defendant's sobriety, which is a properly phrased question, and then went on to explain exactly why he formed that opinion. And in that case, the trial court, or the appellate court, found that there was no substantial risk of miscarriage of justice. Similarly, in Commonwealth v. Columbia, officer said that the defendant was impaired, went on to explain himself, and again, there was no substantial risk of miscarriage of justice, as there wasn't in Canty as well. So I would suggest that while he shouldn't have said it, the error was brief. It was explained by the officer, and it didn't draw an objection. It was also any sort of, I think, prejudice would have been cured by the judge's jury instructions about weighing the evidence and weighing credibility in making the decision theirs to make. So I'd suggest that on all three of the prongs of the defendant's appeal, the intoxication, the operation, as well as the opinion testimony by Officer Brown, I would suggest under the Lattimore standard, the Commonwealth, in light most favorable to the Commonwealth, there's been enough, there's enough evidence before the jury for them to make reasonable inferences and for them to have found the defendant guilty, and that the judge's motion for the defendant's motion for a directed verdict of not guilty should have been denied and was properly denied. And if there's no further questions from Your Honors, I would rest on the Commonwealth's brief.
All right, very good. Good argument, both of you. Thank you very much. Very helpful to us. The case is submitted.
Thank you, Your Honor.
Thank you very much.
All right, you're live and recording.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Singh and Hand. We are hearing argument today by teleconference due to the ongoing pandemic. The rules are the same as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. The next case we will hear is number 20-0080, Commonwealth versus Morris, and we will hear first from Attorney Cates.
Good morning. May it please the court, my name is Tasha Cates and I represent TOREE Morris. From the beginning to the end of his trial, Mr. Morris's defense and character were eviscerated. He was tagged as a serial abuser of women in the Commonwealth's opening statement. He was prevented from presenting evidence that would have supported a necessity defense. And the Commonwealth emphasized to the jury that there were 3 touchings in its closing argument without any evidence that supported that number. I'm intending to discuss all issues in my briefs today. First, turning to the necessity defense. Mr. Morris was prevented from presenting his necessity defense because his statement to police should have been admitted as circumstantial evidence of his state of mind.
Did Mr. Morris ever raise before the trial court his interest in raising necessity defense?
Not in so many words, but he obviously had a real interest in trying to get this statement in. While he did agree in the motion in limine that he wouldn't be using it, I think there's some indication that maybe he didn't understand. And then later during Officer Recupero's cross-examination, he's clearly trying to get that statement in his defense.
Was there any indication that by way of offer of proof or otherwise that had he expressed an interest in a necessity defense, he would have been prepared to introduce evidence to support all of the elements of a necessity defense?
I don't think he got into it at that point, but I think that he could have, given the witnesses that testified. You know, his options generally were very limited for necessity here because Miss Angel didn't testify at trial, so he couldn't ask anything of her. The surveillance video itself doesn't have any audio that might shed any light on anything. And honestly, even if Mr. Morris had testified, he really had to have that statement in. I think his best shot was really to ask Officer Recupero, the person he was trying to ask about his statement, sort of questions that relate to the defense of necessity, the various elements there. I think he could have asked that officer, you know, whether kind of the dangers that someone faces when they're using heroin, and that what a civilian can do if they see someone that's high on heroin, as well as even addressing kind of the legislature aspect of it, where state law, say, permits people to get Narcan if they see somebody who's having a overdose.
I just ask,
But is there
just
anything?
clarify.
No, go ahead.
Sorry, was the statement, I wouldn't let her leave or she wouldn't let me leave?
So that is part of the statement, he wouldn't let her leave. So the full statement, it's not quoted completely in the transcripts, but it's that Miss Angel was addicted to heroin, that she had used heroin just before the incident, and then he wouldn't let her to leave because, as he said, she was all fucked up.
Okay, so what he's trying to get across is that he wouldn't let her leave and he had a reason for that.
Correct.
Correct? Okay. So, and how is this even if you have the necessity defense, how is it a defense to the assault and battery?
It would be an offense to the assault and battery. To be clear, really most of what I'm arguing is really targeted more on the assault and battery and less on the Commonwealth case on the weapons charges.
I guess what I'm saying is if this were a kidnapping charge, you know, confining somebody, not letting them go, then I can see that there is the defense dovetails with that. I didn't let them go because they were a danger to themselves. But I'm having a hard time understanding how this necessity, I didn't let her go, is actually a defense to, I had to beat her up.
Well, so I think the Commonwealth, I believe, has submitted a copy of the video for the panel. So if you watch the video or if you read Detective Chad Bourne's description of it, it's not as though anyone's accusing Mr. Morris of, you know, reeling back and trying to punch her. He's trying to restrain her. She's at the top of the stairs, kind of after going through a hallway, sort of bends over, and then he kind of turns her around and then gets her to go back down toward the.
You're saying that was the assault and battery, not the assumption, not the, are you saying that that's the assault and battery?
I'm saying that that would be the assault and battery. It was originally charged as strangulation, but the court here didn't think that there was enough to charge the jury with that. So they left it was assault and battery.
And what was argued to the jury, was it argued that the touchings in the hallway were the crime, or the strangulation in the room was the crime, or all of any one of those?
I believe that the argument is really the touchings in the hallway. I don't think that Ms. Angel ever says that the strangulation happened in the room or not. She says, she has her spontaneous utterances that, oh, he choked me, but it's never clear.
And the officer sees red marks on her neck, right? Or am I misremembering that?
I don't remember that specifically. What I do remember is that there is supposed to be a cut under one of her eyes, that it's bleeding. She doesn't realize it's there. The officer has to tell her. But
and it doesn't look like that happened out in the hallway, does it? Or we can't tell?
I don't think you can tell. The video quality is okay, but it's not perfect.
I thought that the substance of the charge, the reason for the, the statement that came in was, he choked me, and that really was the substance of the charge. That's the basis for the assault and battery, not what happened in the hallway.
Well, I think the basis for he choked me is for the original strangulation charge that didn't end up getting charged to the jury. That was the lesser included. But the stuff in the hallway, I think, was also supposed to be supportive. There was a assault battery family and household member of which he was acquitted, that was relevant for. I would say that, Mr. Morris's statement, I think that it's really relevant to a material issue in the case, basically the facts of assault and battery, but then also his defense. And I would say that even if you were just looking at one part of it, saying that he wouldn't let her leave as circumstantial evidence of his state of mind, that the rest would come in for verbal completeness. It's the same subject as a statement, it's the same conversation, and I think it's necessary to understand why he said he wouldn't let her leave. Without this, if he really couldn't go for a necessity defense, whether or not he testified. And he's supposed to have the opportunity to establish a defense under the Sixth Amendment, even if it's tenuous, it's still supposed to be permitted. And he was really kind of cut off from it. And so he was left with this much weaker argument that this trial, was based on hearsay because Miss Angel didn't testify. And I don't think that was convincing to the jury.
The problem I have with this is that it wasn't raised below, it wasn't even raised in your brief. It's raised in your reply.
So I would say that there's an overarching argument that there is a hearsay exception that applies here. And while, yes, I did concede in my reply brief that I addressed, the admission by a party opponent in my original, that this is still a hearsay exception, and there still was one that was relevant. And in this case, I'm now saying, it's a circumstantial evidence.
Okay, but don't we have to, even if you had raised it in your brief on appeal, this argument wasn't made to the judge below, right? So wouldn't we be weighing substantial risk of a miscarriage of justice? Well, or do you preserve a different argument just by raising the claim?
I guess my thought is that Mr. Morris had preserved the fact that he wanted to get this statement in.
Oh, okay.
The necessity defense is kind of explaining why he wanted that statement in. Moving on towards the opening statement. Here, the Commonwealth's opening allows the jury to make this conclusion that Mr. Morris is a serial abuser of women without actually presenting anything at trial. It's not a relevant fact here. There's just no evidence that Mr. Morris has a pattern that when women try to walk away from him, that he doesn't take no for an answer and he follows that woman.
So other than the potentially unfortunate phrasing of that first sentence, is there anything else in the opening that suggests that the Commonwealth was relying on outside knowledge of other women whom Mr. Morris had treated similarly, or did it all relate immediately to Ms. Angel?
They don't specifically get into other women. The problem is that they're using this for emphasis at the beginning of the argument, and then they come back to it later in that same argument. So they kind of sandwich the facts that they intend to show at trial with, you're going to see what happens when TOREE Morris doesn't get his way. And to be clear, there's no evidence presented what his way is, and it's in part because Ms. Angel doesn't testify. The jury instructions here really don't address the problem with this particular opening. The trial judge tells the jury, well, there's a roadmap here, what opening statements are. They're not supposed to be substitutes for the evidence, but they're supposed to help you understand. And it's a little tricky when the roadmap that the jury is being given is sandwiched by, and it's emphasized by Mr. Morris abusing multiple women. Kind of how it's meant to be taken. And I find that prejudicial towards Mr. Morris for the Commonwealth to kind of resort to that in its framework. Finally, addressing the closing, there's really no conceivable factual basis to support the Commonwealth's argument that Mr. Morris had touched Ms. Angel 3 times.
How about the video?
So the video, which I believe is available to you, doesn't really show 3 times. It's a continuous course of action. And Detective Chad Warren had testified on the first day of trial. He describes it as basically from the time that Ms. Angel, is trying to leave the building, first time you see her on the video, until Ms. Angel and Mr. Morris are headed back towards out of camera sight. He never describes it as individual touchings. And I've watched the video and I can't describe it that way either.
Well, I've watched the video as well, and I guess I see what you mean, that in some sense it's a continuous act, but he does several different things to her. I mean, and the jurors saw the video themselves. If they didn't think it was 3 separate touchings, then they didn't. If they did, then they did. It doesn't strike me as that that wild a supposition to describe that as more than 1 touching anyway.
I guess, if this was 1 quick mention, it wouldn't be as big a deal, but the Commonwealth is once again doing this for emphasis. They say he doesn't touch her in a way that she clearly has demonstrated by the video. She doesn't want to be touched, not once, not twice, not 3 times. And at the end of their closing argument, they go back to it and they say, they ask the jury to find Mr. Morris guilty of assaulting and beating Amanda Angel 3 times. They harp on it. And I would say it's a significant misrepresentation, and that the jury instructions don't really address the number of touchings versus what the Commonwealth said to what the jury might have seen. The jury did look at the video 1 more time in deliberations according to the question that they had asked. If there is nothing further, I will rest on my briefs.
Seeing nothing, thank you very much. Excellent argument. We will hear next from, assuming clerk's office is ready, but I'm guessing they are, from Attorney Chang.
Good morning. May it please the court. Just wait. Okay, there we go. Kristen Chang for the Commonwealth. On the first issue here, on the issue of the defendant's statement, out of court statement that he was trying to get into evidence through the testimony of Officer Recupero. As an initial matter, I don't see how the defendant can really get past the fact that this was clearly a hearsay statement. The defendant has conceded in his reply brief that it was not a statement of a party opponent, as he had argued in his opening brief.
But it's in the state of mind exception.
I did look at the guide to evidence on this, and I can't see that it even falls under that exception either. If you look at the section that the defendant cites in the reply brief, he cites to 803.3b2. And if you look at that, those types of statements refer to past conduct, not future conduct, a statement of intent. I intend to do something in the future. Here he told the officer that, well, my intent was to keep her in the apartment because I was worried about her. That's it's referring to past conduct. So I don't see that it even falls under that exception. Anyway, if you look further, I think maybe another argument.
But knowing the putting this in for the defendant's state of mind, and I'm not talking about like what's the other exception? The intent, plan, or motive statement. Not including a statement of belief or remembered fact. I'm just talking about state of mind that he believed that she was too wasted to let her go outside. I'm not saying that's true or anything else, but that statement suggests that, and I'm not sure why that mightn't mitigate or even eliminate whatever intent is necessary for assault and battery if you think you're protecting someone. I mean, I don't know enough about the substantive law there, and maybe you can educate me. But to me, if someone says, oh, I touched that person without their permission, but I thought they were going to wander into the street and die, I assume that's not assault and battery anymore.
And I agree with you that it would be extremely relevant if he had testified. We're not even talking about his testimony here. We're talking about his statement.
But there are reasons defendants don't want to testify.
Agreed.
The main one being impeachment by prior convictions. And so in many, many cases, if possible, they do try to get in. I know he's not a lawyer, but they do try to get in their statements made to police or whatever, so their side of the story can be told without exposing them to that risk.
I completely agree. And it's unfortunate that this came up for the first time in a reply brief, because I didn't have the opportunity to really pull up case law and present that to this court in a more meaningful way. But in my review of one, I don't think it falls under the hearsay section that is cited by the defendant. If you even look at circumstantial evidence of the defendant's state of mind, if you look at the cases that follow, and you look at the statements that were made, they're not offered for the truth of the matter asserted. Here, he's looking to admit this statement that my intent was to do this for the truth of the matter, that his intent was to prevent her from committing further harm. So in that sense, I don't think the defendant can get past the fact that this was a hearsay statement he was trying to get in. Nonetheless, I don't think that admission of the state, even with the admission of the statement, he would be able to meet all of the elements necessary for a necessity defense, particularly the third element, enabled to prove that there were no legal alternatives available to assault and battery in this case. And at the same time, as I cite in the other section of my brief, I think the evidence in this case was very, very strong against the defendant. So as Justice Rubin pointed out during my sister's oral argument, I think because this issue was not raised below, it was not even raised in the defendant's opening brief, I think we are looking at substantial risk standard here. So given the evidence at trial, and given the fact that I don't think the defendant would even be able to prove a necessity defense, even with the statement, I don't think the defendant has met his burden here. As to the second issue, looking at the opening statement, and this is a case where if you look at the portion of the opening statement that the defendant points out, just in black and white on the page, just that statement in isolation, as I noted in my footnote, perhaps the phrasing may be better left unsaid, maybe better phrased in a different way. But the case law instructs us that we really have to look at the entire opening statement. We have to look at the evidence submitted at trial. We have to look at the jury instructions. And when you put all of those pieces together, I don't believe that this was improper. If you look at that piece of the opening statement here, and when you look at the video, it's clear she's just documenting what the jury was going to see on the video, step by step.
I don't see how you can say it's not improper. What does this guy do when a woman won't do what he wants? He has his way with her. What evidence supports that?
Well, there's a video that shows him.
It doesn't. And what is it that exactly? How did he not get his way? What was going on between them? There's no audio.
I agree with that, Your Honor. There is no audio. There isn't any direct evidence of the defendant's motive in this case, but there is a video of her trying to get away and him preventing her from getting away. And then there's evidence.
He does this to women. Is that right? He has a propensity to do this to women.
There is no evidence, and that would be improper. I agree, Your Honor, that would be improper. That this is, he's done this before, so he definitely did it here, or he's done this to her.
The language that was used by the prosecutor, doesn't the language suggest? It suggests a general trait of his. He doesn't take no for an answer. You're going to see what happens when he doesn't get his way. He's not talking about the evidence that they're going to see in this case. He's not talking about this is what he did to her in this case. The phrasing is, speaks to a general character trait of his. You've got to admit that that's inappropriate in this type of case.
And I do acknowledge in my brief that the phrasing, it could have been presented in a better way and to more directly link to the evidence. But when you look at the step-by-step and the way this prosecutor laid out what the jury was going to see on this video, I think it links very clearly to the evidence that was presented. And I also want to point out that this was a very, very small portion of the overall opening statement that otherwise very accurately lays out what the prosecutor intended to present here. And she closes out her opening statement, reminding the jury that they are the sole fact finders. It's their job to assess all of the evidence. So she really mirrored what the judge then instructed the jury to do. So putting all these pieces together, like I said, I don't believe there's a substantial risk here. And I would point to the Oliveira case that I cited in my brief. In that case, you know, the court did find that maybe the prosecutor erred in presenting an argument in the prosecutor's opening argument, but given that that error was followed by a more appropriate outline of the evidence and was specifically directed at the anticipated evidence as it was here, there was no substantial risk in that case. And as to the last issue, there's a claimed error that the prosecutor misstated the evidence of 3 instances. As Justice Rubin pointed out during my sister's argument, I think it is arguable that the jury could have found 3 separate instances.
What are I'm sorry, what are the 3 incidents?
Well, I believe you could find 3 instances just on the video itself.
What are they? Tell me what they were.
So first, the victim is approaching the stairway. The defendant comes behind her and turns her towards the left. She stumbles a bit, and then he flips her around the opposite direction and she falls to the floor. So that's 2. And then he picks her up completely on her feet and pushes her back. That's 3 right there from what I can see. Not to mention all the evidence of what likely occurred behind closed doors.
He doesn't stop touching her in between these acts. He's got his hands on her continuously.
That's correct.
But emphasis in the closing at the end, he assaulted her 3 times. I mean, the closing's all about these 3 times. And I, as I suggested to your sister, the jury did see the videotape, but it seems a little misleading to me. I don't know.
Well, the jury had the benefit of seeing exactly what she was talking about. In this case, it's not a case where she was recounting an eyewitness testimony or something like that. The jury was able to see and judge for themselves exactly what went on here. Not to mention there was evidence of the assault continuing to occur behind closed doors later. We have neighbors' testimony that she heard a woman asking for help. We heard officers come in and saw the door broken, go in, saw the defendant towering over the victim. She was on the bed crying. There was officer testimony that she could barely breathe or get out any words. There
was no instruction, and the indictment didn't have a particular to wit indicating which touching was the unlawful assault and battery. Is that right?
Not that I could find, Your Honor, no. Not that I can find. And so there was only really one count of assault and battery that we're looking at here. So she only had to prove 1 instance. And I think any one of those would have been sufficient in this case. So for all of these reasons, if there are no further questions, I'm happy to rest on my brief.
I see none. Thank you very much.
Thank you.
Both of you, excellent arguments, very helpful to us. The case is submitted.
All right, we are live and recording.
Good morning. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined by Justices Singh and Hand. We are hearing Appeals Court. I'm Justice Rubin. It seems problematic. Does anyone know where that's coming from? It's like an echo.
Attorney Hacker, do you have the YouTube page up? Sometimes we have issues with attorneys.
I may. I'm sorry. Hold on. Yes, I did. Sorry about that.
Okay.
No worries.
It's closed now.
We are hearing argument by teleconference due to the ongoing pandemic. The rules for argument are the same as in the courtroom, which is to say 15 minutes per side. And we have only one party presenting today. In the next case, number 20-184, AC versus MK, the case is partially impounded, and so I will caution counsel not to use names, but only initials or plaintiff, defendant, appellant, appellee, and so on. And we will hear from you now, Attorney Hacker.
Thank you, Your Honor, and good morning. My name is Michael Hacker. I represent the appellant AC. My client is participating virtually on the court's YouTube channel, which unfortunately I just had up, as you know. The issue presented by this appeal concerns the showing that a plaintiff must make in order to qualify for an abuse prevention order under Chapter 209A. Here, at the ex parte stage of that statutory scheme, AC testified to rape, sexual assault, and facts that reasonably left her in fear of further abuse at the hands of the defendant. Focusing on the fact that the abuse occurred some months before AC filed her complaint seeking relief, the district court denied AC's request for a restraining order because, and I'm quoting Record Appendix 28 here, the restraining order is for the very specific purpose of being an order that would protect you from serious, imminent physical harm, and I don't see that you've met that burden, close quote. Now, the lower court erred in requiring AC to prove an imminent threat of serious physical harm because that standard,
right
yes.
Okay, so this appeal is from the denial of the motion for reconsideration?
Yes, Your Honor.
Okay, and there was no hearing with respect to that?
No, there wasn't.
Okay, so we're looking at your paper submissions.
Correct, Your Honor.
And the judge had a margin endorsement on the denial of the motion for reconsideration?
Yes, she did.
Okay, and then, so do you want to take us to what that ruling was?
So the judge wrote.
I just get clarification. This is an appeal from both, right? You timely filed a notice of appeal from the first, also motion for reconsideration, and then filed a new notice of appeal after that, after that was denied, right?
We are, yes, Your Honor.
We have both before us.
Yes, Your Honor, that's correct.
I just want to make sure maybe the resolution of one resolves this, but we do have both before us, properly before us.
Yes, you do, Your Honor. We appealed after the order from the
motion. I don't mean to interrupt your answering, Justice Singh. So.
Yes, so the judge in a short margin order wrote that the plaintiff did not meet her burden, that she had an objective, reasonable fear of harm, either imminent or not, from the defendant. I believe that's what that says.
Okay,
so
are you claiming that's error?
Yes, I am, Your Honor.
Okay. And how so?
Well, because Your Honor, the judge explicitly referenced the imminency of the threat, which was the basis for her original decision, where she erroneously required that there be a close temporal proximity between when the alleged abuse occurred and when AC filed her complaint. And that directly contradicts this court's precedents, which we cited pages 12 through 13 and note 4 of our brief. But it also is directly contradicted by the statute, which states that a court shall not deny any complaint filed under this chapter solely because it was not filed within a particular time period after the last alleged incident of abuse.
Okay, so what I want to focus on is this was the last statement made by the judge in the whole succession of hearings, and no objective reasonable fear of harm, either imminent or otherwise.
That is what she wrote, but the decision, as Justice Rubin notes, the decision from the bench focused solely on the imminency of the harm.
Okay, that's clearly true, but I think what Justice Singh is getting at is we now have a statement by the judge, let's say half acknowledging maybe she erred. I think she erred in imminence because I think it's clear that that's not the standard, but we haven't deliberated about that yet. I could be wrong, but that's what I think. I think she applied the wrong standard, the imminent standard. But then at the motion for reconsideration, she appears to be saying, even if I apply the standard you say, just fear of harm, I don't find the burden is met. Now, that could mean one of two things. It could mean because I accept all this evidence that this plaintiff has put in, I find the plaintiff credible. Certainly, if you read the transcript, it seems like she does find the plaintiff credible, but it's not enough. I think that might be an error of law. I mean, I read the transcript and I see someone who is not taking seriously the conduct of this person in this workplace environment, and whether it's because it's the comedy community and the judge doesn't get what that is, or of course, I also have concerns that there may be issues of understanding transgender relationships and so on. And it's not clear to me. The judge doesn't say anything like that, but of course, that is lurking in the background here.
Certainly.
On the other hand, the judge might mean, I didn't find any of this credible. I don't think any of this happened. And therefore, I don't think she's met her burden of showing fear of harm. So what do we do if that's our circumstance? We don't know what she's saying.
Well, what we're asking for, the relief that we're asking for here is either to hold another ex parte hearing in which the judge applies what we believe is the correct legal standard and ignores the imminence, which the judge previously focused on, or to schedule this for a 10-day hearing at which the defendant is present and has the opportunity to rebut the plaintiff's testimony, at which point I think it would be perfectly appropriate to make a determination as to whether there was whether the plaintiff was still reasonably in fear of the defendant. Because as Your Honor notes, the plaintiff testified to both assault, rape, and seeing the defendant as recently as the month before filing her complaint at a local bar where she was performing comedy. And the defendant is also in this same line of work in Northampton. And so it was likely that the plaintiff would run into the defendant, and in fact did, especially at night in a bar where abuse was likely to occur. And so I take Your Honor's point, and I thank you for it. I think it was legal error to conclude that there was not a reasonable fear of harm here, especially at the ex parte stage.
Is the judge entitled to make a credibility determination at an ex parte hearing?
Yes, Your Honor, I believe they are.
What case can you point us to that would explain how detailed the judge's findings have to be in denying an ex parte order or denying a motion for reconsideration under these circumstances?
So unfortunately, I was unable to find a written decision where from an ex parte stage of the proceeding. I don't know if that's because these are routinely granted or because these are typically filed by pro se plaintiffs who don't know that they have a right to appeal. I don't know the reason why there is lacking case law in this area. But the cases that we cite to at pages 12 through 13 and footnote 4 of our brief highlight that I think this is a legal error that occurs often, that this court and the SJC have corrected previously, which is that judges require that a plaintiff prove that the abuse occurred shortly before they filed their complaint. And if they can't prove that, then the district courts determine that they're not reasonably still in fear.
I think I phrased my question poorly. So what I'm looking to is more the issue that Justice Rubin raised, I think, with respect to the possibility that the judge didn't credit your client's account of what happened. And that's the reason why on the motion for reconsideration, the motion was denied. To what extent was the judge required to make explicit that fact, the lack of crediting the testimony, if that's what happened?
I don't believe that she was required to explicitly say whether or not she was crediting the testimony. I think to the extent it's unclear the basis upon which her decision was made, remand for further proceedings would be appropriate. But I don't have a specific case site in mind for that, Your Honor.
Can I ask you about the remedy you seek? You say you seek I don't understand how a 10-day hearing would work, because it's actually more like 2 years and 10 days since this was filed. Presumably, a new hearing would require introduction of new evidence to show current fear, not of imminent harm, but that the fear endures, right? So for example, I know nothing about this and I don't want to really, because that's outside the record. Perhaps the defendant lives in Georgia now, or, right? Maybe there's just no basis for this. But are you asking, when you say you're asking for a new 10-day hearing, you mean to prove current fear? Or, I mean, I don't know if it's a question of mootness or something, but what was going on 2 years ago seems irrelevant, right?
Well, respectfully, Your Honor, I disagree that what was going on 2 years ago is irrelevant.
No, I don't mean that it's clear, I don't mean that it's utterly irrelevant. She may continue to be in fear, reasonable fear.
That's where I was going.
I get that. But I'm saying the demonstration would be about the day of the hearing, right? Not about some day 2 years ago. Is that right?
Yes, I think that is correct. I think the fact that there's a global pandemic drastically shifts the evidence that the plaintiff would put on at a new 10-day hearing versus what she may have been able to put before the judge without.
We don't know when that hearing would, I mean, if we were to agree with you, which I'm not saying we will, we haven't deliberated about the case. Of course, we don't know how long it would take before there's exactly what day the hearing would be on.
Can I ask you a practical thing? You mentioned, that one of the issues was not having a proper, address to serve the person. And I believe that there were work addresses that were given, although we don't have them in the record. We don't know how complete any of those addresses were. And you're indicating that that shouldn't prevent this case from being put on for a two-party hearing. What would happen? I mean, let's see, your position in your brief is that there's no requirement that that someone coming in for a restraining order have any information about the other party. So what, practically speaking, what would happen? The court puts it on for a hearing. The other party, there's no service because nobody knows, where they really are. And don't you really have what the judge said is a piece of paper? You end up with a piece of paper. I mean, where do you go from there?
So we do make that point, although just in a footnote, and that's not the basis for our appeal. But I take Your Honor's point that the first hearing before the district judge involved this question of, how do I serve the defendant if I don't have an address? And so the district judge asked the plaintiff to come back, which she did that next Monday. And she told the court and the court officers that the defendant worked at the Social Security office in Western Mass. And so I would submit that they do have a 9-to-5 work address where they could serve the defendant and that they could be noticed of a new 10-day hearing. So I think that there is an address at which to serve the defendant is, I think, what I'm saying.
All right, but the larger point that there's no requirement for the plaintiff to provide any information about the other party. You agree that the hearing really can't go anyplace if the plaintiff doesn't come forward with something.
The 10-day hearing could not go forward if the defendant was not present for that hearing, and it would be I think that the SJC has held that it is a due process violation if the defendant is not served and the 10-day hearing goes forward regardless. So if the defendant was not served, then yeah, the 10-day hearing could not happen, but there is a 9-to-5 work address. The defendant could be served and a new 10-day hearing could be held.
I have one more question. And this has to do do you agree that it's a different or the same standard when someone comes and is requesting an ex parte immediate issuance of an order versus simply just making their case in order to have another hearing?
It is a different standard under Chapter 209A. That's Section 4 of 209A. And in order to obtain an abuse prevention order at the ex parte stage, a plaintiff must prove that there is a substantial likelihood of immediate danger of abuse. Now, again, this only applies at the ex parte stage. That standard is irrelevant at any other stage of the proceeding. But to the extent that the panel is concerned about the implication of Section 4, I would argue that there are at least 4 reasons why that language in Section 4 does not change the outcome here. The first is that I think the evidence that AC presented to the district court fully satisfied that standard, in that she testified to 2 incidents of sexual assault and rape, and to regularly seeing the defendant in public and reasonably still being in fear of the defendant. And so even though the abuse may have occurred some months before she filed her complaint, she was still in a substantial likelihood of immediate danger of abuse at the time of the ex parte hearing.
Well, your time has expired, and you purport to have 3 more points. So I want you to make them quickly,
Sure.
because I do want you to answer Justice Singh's question. But my understanding of what the abuse looks like in this case that has to be imminent is simply exacerbation of the ongoing harm of the prior sexual assaults, right? So that's what has to be imminent. And that might be that she's going to imminently run into the defendant rather than imminently be assaulted again.
That's exactly right, Your Honor. And this court in the Vitone case, which we cite in our brief, said, and I'm quoting, "The infliction of some wounds may be so traumatic that the passage of time alone does not mitigate the victim's fear of the perpetrator," which I think is an acknowledgement, and other cases we cite in our brief acknowledge this, that after someone has been abused, especially in the manner in which AC was here, any interaction with the defendant can, set off the same emotional response that they had the prior time, and that constitutes abuse, and that is what AC feared and felt when she went out in her community and tried to engage in her job. And as she testified to the district court, she was avoiding work out of fear of the defendant. I'm out of time. I have several other points, but I think I've made them already.
If Justice Singh wants to hear more about this, the ex parte hearing, of course she's entitled. So
That's fine. I think you have answered my questions there.
Okay, thank you, Your Honor.
All right, thank you very much. Your time has expired. Thank you for an excellent argument they've provided us with. And so the next case is number 20-178. This is an impounded case, Department of Children and Families versus Children. And I will remind the parties of the impoundment order. So perhaps using phrases like the older child, the younger child, the twins, mother, father would be best. We will hear first from Attorney Alderman Boyer, who is counsel for the children.
Good morning, Your Honors. May it please the court. I represent the 2 children in this case, and I just want to draw attention to the fact, and just as a reminder, that the older of the 2 children was removed from the care and protection back in 2019. And so the focus of this case, as mom was found to be fit for that child. There are also 2 younger children that were not part of the care and protection. They're twin girls. They're currently 3 years old. The older is 7. And although they weren't part of the care and protection, the judge did find in her findings that she basically meets the needs of those kids by clear and convincing evidence. And so the real focus today is on the 5-year-old, the middle child, if you will, or the youngest of the 2 appellants. Your Honor, I would argue today that I feel this case is extremely important. This child, this 5-year-old child, is the only child of all of mother's 4 children whom mother has been deemed to be unfit. I would argue on behalf of this child that this finding of unfitness is not supported by clear and convincing evidence in the record. In that there is so much at stake here for this child. This child has been denied her rights, her constitutional right to her mother, which is under Sabot versus District Attorney's Office of Suffolk. And the Commonwealth has recognized a right to your natural family under custody of a minor, where the court states the Commonwealth may not attempt to force the breakup of a natural family without an affirmative showing of parental unfitness. This child has been deprived of the relationships of her 3 sisters and her mother since she was 22 months old, and she is now going on 5.
I ask you a couple of questions, and I apologize because these go outside the record, but how recently have you actually spoken with the 5-year-old herself?
I spoke with her on Saturday, Your Honor.
Are there ongoing visits between the mother and the 5-year-old?
So my understanding, and as you know, I am, if you would like me to respond to that outside of the record, I'd be happy to do that. As far as I know, there are. I would say, as being a trial attorney and doing this type of work, you know, the department's consideration of ongoing visits versus mom, and if there's barriers and so forth, are things that can always be litigated out. But my understanding is she is.
Is the child still in the same placement she was in at the time of trial?
She is, Your Honor.
If we were to agree with you that the findings aren't adequate to show by clear and convincing evidence unfitness, what procedure would we follow? Now we have a child, we'd have to remand, and presumably there'd have to be a new best interests determination, or
So, Your Honor, what I would argue is that if there's no finding of unfitness, that reunification should occur immediately.
well, I understand that argument, but don't we need new information about the nature of the bond between the child and this family she's now been with for years, her current status of her bond with her mother, to get some sense? I mean, her mother might be unfit, quote unquote unfit, that is incapable of meeting her needs, precisely because of the difficulty that might ensue at this date that might not have ensued 2 years ago if she were removed from a home she's been in for 3 years, right? That might create needs that no other parent could meet.
So, Your Honor, at trial, this was not brought up as an issue. Whether there was no evidence.
Trial was 2 years ago. I'm asking about procedurally what should happen now. I mean, I understand, of course, you can always take, if there's an error, you can return a child to the custody of their parent, even if the only family they've ever known for a decade is their pre-adoptive family. But nobody would do that lightly.
Correct, Your Honor. My understanding is this child is very aware of her siblings. She knows who they are. She knows who her mother is. There is no evidence that clearly that when any child is reunified with a parent, you would want to put things in place, maybe a parent aide or a therapist to help with the transition. But you know, I do this work for a living, and a lot of experts would say if there is no issue with attachment, if there is no past issue with attachment, that they should be able to reattach. And there also wasn't any evidence that she isn't bonded with her parent, with her mom and her sisters. In fact, at the trial, the social worker had actually suggested
I am just asking about now.
Yes, Your Honor. I mean, I suppose I would say to you, Your Honor, that I do not, it's not an answer I can give you easily without an expert actually talking about this. Yes. But I would say that based on the situation, this is a home where this child has no other siblings, there's no other children in, and that her relationships with her siblings that in essence last you for the rest of your life, and they're incredibly essential relationships, that it would be worth actually doing whatever it takes to get her safely into that environment so that she may have these relationships for the rest of her life. She does not have those in the placement that she's in. She is alone. She's the only child.
Is your judgment that the position of the child is or should be for reversal here? Is that a matter of substituted judgment by you? Or is that a matter of her own judgment, although she's obviously very young? How did she come to this position?
So, Your Honor, I did speak with the child, and based on conversations, she had expressed wanting to go home to me. And also based on speaking with her trial attorney, which the position has always been to return home throughout, and also looking at the record.
But that's 2 years ago. You're pressing the appeal now?
No, Your Honor, not based on 2 years ago conversation with my client. This is, that's not 2 years ago. So this is based on conversation with my client, also ongoing conversations with trial attorney in the record.
Okay. I've taken a lot of your time and you only had 7 minutes. So if you want to go a little over, that's fine. So Your Honor, basically, I would argue that in this case, speculation has driven this case from the beginning. Even back in 2017, this child was removed in 2016, and in 2017, mother had completed her service plan tasks, and foster care review sent the older of these children home. It did not send the younger one based on speculation that she may need eye surgery that she never needed. And I just want to make clear to this court that mother's providers, the people that she has worked with, parent aid, the director of her housing, even the court investigator, all stated that that this child should be sent home, that mother is capable and she is caring, and that she has there been an incident of medical neglect in this case. There was no expert evidence in this case. This child had serious or significant issues. And certainly mother has a history of being a CNA. She is very competent to handle medical situations. And I would just kind of emphasize to this court that our rights to our families are paramount. They are so important, and that this child should not be denied or continue to be denied. Every day that she's out of her home, she continues to miss on those important moments of laughing with her sisters, waking up with her sisters. These are 4 sisters, 7 years old and younger. They are very close in age, and she is missing out on all of the beauty that we have with our siblings. And again, I would say there's been no expert testimony here, but I know in the past with experts that if a child hasn't had trouble attaching in the past, they should not have trouble in the future with reattachments. And I would say that she still has those attachments, that she hasn't lost those attachments. So I would just say that for the sake of this child, the decisions we're making today will affect her for the rest of her life. She's only 5. She has a whole life to go. And having 3 sisters is a gift. Having a mother who's competent and caring is a gift. And these rights have to be safeguarded. And this court, as a reviewing court, and I just would like to just in closing just say an adoption of Rona. It says a judge's findings must be left undisturbed absent of showing that they are clearly erroneous. A finding is clearly erroneous when there is no evidence to support it, or when, although there is evidence to support it, the reviewing court on the entire evidence is left with the definite and confirm conviction that a mistake has been committed. And I cannot say that I don't look at this case and say a mistake has been committed, not just by the trial court, but with the department going back in 2017. She has been deprived of her rights to her family. And I do not think that that should continue not one more day for this child. All right, thank you.
Thank you, Your Honor.
Expired. Unless there's anything else you want to tell us, are you good? I mean, I want to make sure the child's position is.
Yes, Your Honor. I mean, I feel like you have my brief, and I would just say that a lot of this is based on medical issues. And at the time of trial, there really is nothing that I can say: eczema, wearing glasses, allergies, and any of the behavioral issues the judge mentioned, needing redirection. She may run. This is a 3-year-old child. These are common things.
And this is in your brief as well.
This is all in my brief too, and mother is a CNA and she is well-versed in anything medical, but certainly anything at trial that was brought up would not require any kind of significant medical information. There certainly wasn't any expert testimony saying that, you know, this child has very significant eczema or very significant, they're all basic childhood issues.
I think we understand the facts. We will hear next from Attorney O'Brien, representing mother. You're muted, Attorney O'Brien, that's okay.
May it please the court, Tamika O'Brien on behalf of the mother. Your Honor, in my short time here, I think I'd like to address, if it's okay with you, what you were discussing with Child's Counsel about the procedurally what should happen next. I don't think any, go ahead.
You should bear in mind, we haven't decided.
No, of course, no. Well, let me ask, would you like me to address?
Yeah, no, that's fine.
Okay. I think that this child has been in this home for this period of time. She probably does have an attachment to the foster parent. She also has an attachment to mother. So a slow transition home would probably be ideal, and probably with some kind of family therapy. But that's not to say that just because this child has been in this home with these people, with this family, that she should not be with her biological family. And in this situation, Your Honors, we have a mother who is, she's not subpar in this case. She's not. She has been sober for 5 years, has stable housing, complied with DCF. She was seen by collaterals, the housing director and her parent partner, as having been seen with the children and caring for those children competently and calmly. There were never any concerns during her unsupervised visits with these children, especially including the younger child at issue here, of whether or not she could handle these children. And I think it's important to note that this weekend I did some research, just kind of went through some of the case law again, and I was looking at adoption of lioness. And in that case, as the court obviously knows, the trial court looked at stale evidence, and the same thing happened here. There was a lot of talk about mother's messy house. Well, that was from 2 years ago. There was a lot of talk about this younger child's medical issues.
Yeah, but that's not, the judge was very clear and thoughtful, it seems to me, and what made quite clear this isn't about a messy house. I think everyone is impressed actually with the steps that mother has taken, both to find sobriety and to eliminate from her life abusive partners, although of course we don't know what's happened in the 2 ensuing years, but that she has a very, very difficult older daughter, and who, among other things, has been suspended from kindergarten and has some violent behaviors. And there is at least some concern, although maybe it's diminished, that this younger child has some similar, if not quite as pronounced, behaviors, and that it's just going to be too much. And I think that if that were shown by clear and convincing evidence, then you'd have a situation where, you know, just too much means inability to care for both of them. I'm not saying this met that standard or not, but that's what's going on here. And so I guess I'd say, where is the judge? I understand that's predictive, of course. Your sister used the word speculative. It's predictive. I don't know if it's merely speculative. Maybe it is, but well, I think it's more predictive, right? We always have these phrases, you don't have to wait for something terrible to happen, this and that. She's keeping it together with the 3 kids. It's kind of a magnificent breakthrough. Why is the judge wrong that it's too much to add another, you know, child with some degree of difficulty? Sure. And I don't mean putting eczema cream on the child. I think we can all agree that this mother would be able to put cream on a child's eczema.
Sure. Your Honor, I see my time's expired, but I would.
No, please.
Thank you. Your Honor, mother argues that she doesn't just disagree with the weight of the evidence here. She argues that the evidence needed to prove this case and prove mother's unfitness by clear and convincing evidence just wasn't there. The trial judge simply, in her findings, didn't even comment about the collaterals having seen the mother with the children and how she handled it.
Did the judge explain why the court investigator's report wasn't either credited or even utilized? I didn't see reference to it in the findings, although I read a little about it in some of the briefs.
Sure. And again, I didn't see reference to that either. So I don't have an answer for you on that one. But what I will say is this, that this child, at the time of trial, she had no services for cognitive issues. She was not in therapy. She did not have an IEP. And
but they were trying to get an IEP for her.
They were trying, but there wasn't one.
Well, there must have been a reason they were trying, because it's hard to get one in a lot of work. And if you don't need one, you know, or don't at least think you need one, you don't ask for one.
Sure. Well, you might think you need one, but in this case, there was no proof that she needed one or that one was imminent or that this mother couldn't handle this. In fact, with the other child, the older child, she had that child seeing the school adjustment counselor every single day. That's pretty impressive. Every single day. And she was in touch with that school adjustment counselor.
It is impressive, but it also indicates the degree of difficulty that parenting that child entails.
Your Honor, I just, again, I don't want to take too much time, but I think that it's important that in this case, simply put, the evidence here was lackluster at best. And clear and convincing evidence has to mean something in the courts. Otherwise, these families don't stand a chance.
Do you take a position, does mother take a position with respect to father's appeal? I know the children don't.
I'm sorry, could you clarify?
I'm asking whether mother takes any position with respect to the termination of father's parental rights.
No, sir, she does not. Thank you, Your Honors.
All right, thank you for your time and for taking the extra time. We will hear now from Counsel Father, Mr. Yanoff.
Good morning, Your Honor. My name is Warren Yanoff, and I represent the father in this case. There are basically two issues that I wish to address. First one being that the termination with regard to the elder child should never have occurred as a matter of law. The case against her, the CMP against her, was dismissed. As a result of the dismissal, there's really no authority by the court to terminate his rights.
It wasn't dismissed at the time his rights were terminated.
The goal was to return the child, and the child had been returned to the mother. The CMP was dismissed, and
after the termination of the father's rights by several months, right?
I suppose technically, but I think that's form over substance. But even that being the case, the judge made no findings as to best interest. Father was not contesting that at the time he was not able to care for this child. He had spent 2 years in jail waiting trial, of which he was found not guilty. This is a pretty serious and heavy price to pay because he could not afford bail. And the foster care review indicates that the department didn't try to ameliorate or keep the relationship between father and his children during that time. He was compliant as best he could, and that's what the foster care reviews during this whole period. There has never been an allegation that he has ever been inappropriate or abused either of these children. There's no issue. A week before trial, he has gone into a sober house. This is similar to a Carlos situation where at best his unfitness might be temporary, but in reality, it's unnecessary. Even the judge said it is not necessary to terminate his rights. There was no clear and convincing evidence that it is in the child or both children's best interest to terminate his rights. Doing so, and as I cite examples in my brief, have market effects and shouldn't be. The judge didn't even order post, I'll say, I'm not sure if there's no termination with regard to mother. He's not able to go into probate court, and it makes no sense. If, according to the judge, and this court doesn't do that, everybody who is arrested, incarcerated, has a DUI, has substance problems, we don't terminate their rights. The probate court handles that on a regular basis. It is not to suggest, I would think the probate court, if they needed to set up, whether it be supervised visits, appropriate visits, whether mother could, if she chose to, pretend, have a normal visitation schedule without any court involvement. She doesn't want to be in fear that if she gives visits to the father, notwithstanding the judge's order, that she could lose these children again. So there's no best interest holding. There's no expert that testified as required to say, this is in the children's best interest. The judge conflated, if you will, the concept of being unfit with the best interest. The department erroneously says there's no stability. That's just not true. Every custody issue, modification, parents who don't live together, there's theoretically a stability issue because a modification is always appropriate. These children are very young. Who is to suggest that he cannot be a good parent? That doesn't give him a chance, even if he has other children. It's just not right when we terminate unnecessarily. It's not about the convenience of DCF. The case with regard to the eldest child is not going to be subject to review and redetermination, even if his thing were to be, his parental rights were dismissed as argued in the department's brief. It's just wrong in that respect to terminate somebody who spent 2 years, I'm going to say, unfortunately incarcerated because he couldn't afford the bail, found not guilty, has been addressing the substance issues, and quite frankly, you've got a fit parent that the department says, and there's nothing that would indicate that the probate court could not establish an appropriate visitation schedule.
Okay. Your time has expired. I think we understand your argument. You're next from, I'm getting an echo from somebody's, I don't know whose thing, Attorney Fisher-Groban for DCF.
Yes, thank you, Your Honor. Phoebe Fisher-Groban on behalf of the Department of Children and Families. I want to focus the court on the evidence in the record arising to clear and convincing evidence of mother's unfitness to parent. I'll refer to the child at issue as the child. And I want to focus on two particular categories of evidence. The first is the evidence during the year before trial that mother simply didn't regularly visit the child. So for example, from November 2017, a year after the child was removed, to March 2018, mother missed half of her scheduled visits with her daughter. Once the visits were changed.
What do you take that to demonstrate? That she lacks care and concern?
We take that to demonstrate that mother's ability to parent children is at capacity. In other words, by virtue of mother's responsibilities towards the twins and the older child, mother is unable to parent the child. In other words, she
Your sister says that's not a good test at all. having a fourth child in a house that already has three is a lot different than having to schlep someplace and try to visit one who's off somewhere when you got three at home. It's a completely different thing. And it doesn't demonstrate that she couldn't have the fourth child if she were in the house. What's your response to that argument?
My response to that argument is it does demonstrate that mother is unable to make the time for this child. After her visits were switched to bi-weekly, in other words, every 2 weeks, and I note that these visits were walking distance of where mother lives, and they were scheduled from her days off from work, mother still missed about half of her scheduled visits with her daughter, including a visit during the weeks of trial. So this evidence suggests that mother did not comply with the tasks on her action plan, chief among which was visiting her daughter, but also that she was just simply unable to meet her responsibilities to this child in addition to her other children, which brings me also to her failure to attend her daughter's medical appointments. The evidence is clear in this case that mother also failed to regularly attend medical appointments.
Well, this is a harder case to make because these are scheduled around the schedules of the foster parents. She did go all the way to Boston twice. I know there were 3 visits, but that's a 274 mile, someone wrote in their brief, round trip. I mean, I think that's the visiting the child on her day off, that strikes me as having some weight to it, but I think it's awfully hard. There's gonna be an adult there, which is to say the foster parent, and it's not when her day is off, and it's, you know, I don't know, that just seems to say she couldn't make it to a medical appointment if she had scheduled it herself, again, seems a little different. I'm not saying any of this is good. I think we would all, if we were in this very unfortunate and terrible situation, we would give every effort to seeing the child we're separated from. I get that, but these are difficult circumstances for financial and other reasons.
Your Honor, I want to point the court to one piece of evidence that bears on your inquiry. According to the court investigator's January 2017 report, his review of the child's pediatric records showed that when the child was in mother's custody, the child had missed 6 pediatrician appointments. So this is a pattern that we see when the child is in mother's custody, and then when the child is removed from her custody, she is repeatedly every month.
Did the judge make a finding about that? Is that in the
Your Honor, I can't cite a specific finding at this moment. However, the record cite for the court investigator's report in this particular piece of information is volume 1 of the exhibits at page 11.
Do you know why the investigator's report isn't a focus of anything the judge says? Did the judge discredit it or something?
The judge didn't make an explicit finding discrediting the court investigator's report. However, I mean, the judge's findings are detailed, and the court heard, you know, hours and hours of testimony from the mother, from the father, from the foster mother, and from the social worker in particular. So the court heard and relied on a significant amount of evidence in this case, in addition to the exhibits in the record. The court investigator's report in this case, the first one you'll note, I believe mother didn't respond to any of his calls, so he was unable to meet with mother. And in the second one, you know, he does a review of the evidence, but the court did rely and made very detailed findings of fact based on the days and days of witness testimony, including from the social worker who's been working with this family consistently from the beginning about mother's abilities with respect to all of these children, but most specifically with respect to this one child who does have regular medical appointments that mother doesn't attend, despite being reminded every month, the record shows, by the social worker to say, you know, you've got to attend these medical appointments, you have to know what's going on with her. And the trial court, the juvenile court, did explicitly not credit mother's testimony that she got insufficient notice, and did credit the testimony of the social worker that in many instances she got a month's notice of these appointments, but sometimes got fewer. But for example, in the appointment in Boston that mother missed, she claimed she missed it because her cell phone with a reminder was stolen. So there wasn't an issue of notice there. It was rather that something happened in the week in advance. This evidence is important because whereas, as Your Honor asked, this is a child who, if it were in mother's home, mother wouldn't have to visit her. But this is a child who would still have to go to doctor's appointments. And the persistent pattern in this case shows that mother is unable to attend these doctor's appointments, which this child
needs. Take the other 3 children to doctor's appointments or misses them?
Because the twins were not the subject of this care and protection case, there's kind of limited evidence about the twins. The evidence does suggest that there is evidence again in the court investigator's report about children missing visits when all children were in her custody.
But you haven't removed the other child. You put the other child back with her. Is she missing? Was she missing visits with that child too?
Yes, and I want to move on to
No. I want to stop with that. Why then does that child go back to the missed visits house and this child doesn't?
Because the procedural history in this case shows that the reason why the court didn't return the older child to mother was because the court gave the mother more time to see if the mother would take the older child to therapy. In other words, the evidence was clear in this case that consistently there was a service plan task that mother seek mental health services for this child. The record shows that mother took this child to a handful of appointments for about a month and then simply stopped going. And
why not put this child back in the house too, with the condition that she go to appointments and in 6 months you'll see if she's taking the kid to the doctor or not? I mean, the problem I have here, and it's something your sisters have alluded to. Here's this family. And she does have, it's her biological family. She has siblings. The mother, maybe she would be overwhelmed by this. That wouldn't shock me if having the 4th child were too much. But the child was removed because she stood by while a boyfriend was physically abusive. That boyfriend is long gone. The goal was not changed to reunification, but switched to permanency because it was thought the child would need eye surgery, which is obviously involves a long recuperative period, probably. I don't know what the difficulties are, but I'm sure there are difficulties. But the child never got the surgery. But DCF, it leaves me wondering, why hasn't this child been put back, even temporarily or whatever, with her mother? I just don't understand that.
The evidence at trial showed that at the time of trial, the older child, and as the court explains in detail in her findings, was a child with significant behavioral issues.
Why isn't that the child you removed? How did you pick which one? Toss a coin?
Because that child had significant behavioral issues. The child at issue here had behavioral issues that were addressed by her foster mother, and she had medical issues, and the mother failed to go to her medical appointments and therefore be knowledgeable about the medical issues, and the mother persistently failed to visit with this child.
She didn't put the older child in therapy when asked, but you returned that child to her.
The trial court returned that child to her after taking additional evidence that's not in the record on appeal.
DCF's position was to return that child, right?
Yes. Yes, and that's because the needs of that child were for mental health services. At the time of trial, mother hadn't engaged or set up these mental health services for this child. And again, we see the pattern of just simply stopping to attend appointments for that child, even though she badly needed these services. After trial, the mother did engage with services for this child, and therefore the child was returned to her.
Okay, but so why didn't you give her the chance? My understanding of the medical appointments she still has are quarterly, once every 3 months. Why not have a 6-month period where you see if she takes her to the first 2 visits, see what goes on? I mean, I'm not saying she will or she won't, and I'm certainly not saying she's the greatest parent ever or that this won't be burdensome, but she is the biological mother of these children.
The question of will she or won't she is answered by the pattern that the trial court saw in the year before she was returned. So again, we have this evidence that when the child was in her custody, she missed pediatrician appointments. In August 2018, a mother missed one of the appointments with the eye doctor. The week before trial, mother missed another one of the appointments with the eye doctor.
But you do not have an answer to my question. But my question is, okay, and she missed therapy appointments and canceled them and stopped therapy on and off with the older child. And yet DCF took the position, we'll try to reunify. And if she can get this therapy thing up and running, we'll end the care and protection case. You didn't do that with this child, even once you knew that she didn't need surgery. And I can't quite understand why not.
The surgery was an important consideration for this child, but she also has other medical problems that necessitate visits to medical professionals. And she has secretions from her ears. But again, the evidence shows, the children make the argument, well, mother could attend these appointments, but she didn't. The record before the court was just simply that on the evidence in front of the court, when mother had been reminded every month about her obligation to attend these medical appointments, that she just simply didn't.
Part of what's troubling me here, I should say, is the children's position. We see these cases unfortunately, all the time. And they're always terrible cases in this terrible, difficult case. Usually, the child will show up, the mom and dad are appealing, and the child's lawyer will say, this child is thriving in this new environment. It's a terrible situation in the old environment. She deserves the finality of being in the new environment permanently. Please don't reverse what happened below. And there's just literally no one in this family on DCF's side.
Your Honor, respectfully, the question before this court is the evidence in the record and not the evidence outside.
Well, it is the evidence in the record. But frequently we see a child saying, like, look at the evidence in the record. And what we're hearing here from the child, and I understand it's counsel and 5-year-olds don't get to decide and the court has to do what's in the child's best interest. And God willing, DCF does the same. And I get obviously what our role is, but there's something about this case. I don't know.
Your Honor, I see that. I apologize for interrupting. I see that I have a minute left, and so I would like to turn to the father in this case. Your Honor, in this case, the evidence was clear and convincing at trial that father was struggled with very serious addiction issues and persistent recidivism. I don't intend to focus on the period of time that he was incarcerated as a result of a charge for which he was acquitted. Rather, it's important to look at the 3 months when he was in the community. He quickly relapsed, he quickly was arrested on new offenses, and he failed, except for once, to visit with his children. On the question—
I think it's clear and convincing that he's unfit, and I don't see a problem with the prediction that will go into the future. Your brother says 2 things. One is that doesn't make it in the best interest of the child to terminate. And the second is that maybe with respect to the child that went back to the mother, how can a court terminate? So
Your Honor, I want to direct everyone's attention, or your attention rather, the court's attention to the Willow case, in which case the court did terminate the rights of one parent. So this is something that the court may do and did in this case. It's also important, the point that Your Honor was making earlier, which is that the father's parental rights were terminated before the care and protection was dismissed. And there is no case law that I am aware of saying that when this happens, when the father's rights are terminated and then the care and protection is dismissed, that somehow this termination is a nullity. Here—
Well, your brother says that elevates form over substance, and there's something to that, isn't there? Right, everyone knew, we were all hoping the kid was already with the mother, and we were all hoping that there could be a bow put on it, and eventually there was.
Your Honor, I disagree on the importance of in this case, form is important. The trial court, based on very clear and convincing evidence, terminated the father's rights. The case law is clear that this is important because it provides stability for the child. The trial court left visitation with the father up to the discretion of the parents and the custodial guardian of these children. In other words,
your brother says, and your time has expired, but your brother says, letting the child visit with someone about whom it has been held, it is not in their best interests to have any legal relationship with him, might well open her up to an allegation that she's doing something wrong.
Your Honor, I think that that's a hypothetical which doesn't apply here, because here we have the trial court saying in its orders after trial that visitation is left up to the mother, and she may do so at her discretion, as well as the guardians of the child at issue here. And so therefore the trial court blessed visitation to the extent that they consider it appropriate.
Okay.
Unless the court has any.
Your time has expired, but I've dominated the argument. So if my sisters have anything to, no? All right. Thank you very, very much, all of you. Very helpful arguments. As I say, a sad case. These were all difficult cases for us. So the case is submitted. Thank you.
All right, we are live and recording.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Singh and Hand. We will be hearing one more case this morning. It's number 19-1701, Porter versus the Board of Appeal of the City of Boston. We are hearing the argument by teleconference due to the ongoing pandemic. However, the rules for argument remain the same, which is 15 minutes per side with no rebuttal. And we will hear first today from Mr. Porter, who's appearing pro se. We know it's difficult to appear pro se, and there may be some aspects of this with which you're unfamiliar, but we will try to assist as best we can. Mr. Porter.
Thank you for your generosity in offering that. I'm getting a bit of back sound. All right, I think it's gone now. I appreciate the court offering me the considerations of pro se. I think what my brief and reply brief speak strongly towards my case. I will quickly address some issues. In regards to standing, the defense nor the city presented any witness or expert testimony towards my property being directly across the street from the other property.
Can I interrupt you, Mr. Porter, and could I just ask a question? Your complaint alleges that you're in a butter. However, it appears to me that in responding to the motion to dismiss, you took the position that you are not in a butter, but you were directly across the street. Which position are you taking?
I'm taking that I'm directly across the street, which based on Murrow versus Esch Circus Arts, I have standing. So I'm not
Where does that appear in your complaint? How would we get that from your complaint?
In terms of the complaint, I don't have the complaint in front of me. I'm looking at my my brief, to be honest. So it's my understanding that basically Murrow versus Esch Circus Arts equates the two, that a direct abutter and being directly across the street is the same thing.
Well, they provide, under the statute, they are two different things that each of which may provide party and interest status. I mean, I will say, and Justice Hand, I don't know if this isn't what she's getting at, but if this case were to proceed, one of the problems of being pro se is that one makes mistakes that can end a case. And I'm not saying that's what's happened here, because we haven't talked about the case, deliberated together about the case or heard all of the arguments. But, you know, to actually win a case like this, you kind of need a lawyer.
Okay.
That's just my observation. But in any event, you may want to go on with your argument, but that's what happens. And the truth is, and it's not surprising, this is why there are lawyers. Just in reading through your papers and your brief, there are things that you conflate without realizing it. And that's not unusual for someone who's not trained in the law. I mean, you know, people don't, I mean, that's part of why we go to school and practice for years and so on to understand these different categories that maybe appear meaningless to a lay person, but that have some significance. But go on with your argument, please.
Okay. Again, I have to sort of rely on a lot of what I've written. So based on Moreau versus S. Circuits Arts, I believe I have standing. The city has made no contradiction. The defense has made no contradiction to that. I presented visual representations, maps, what have you, and we have no testimony or witness to stating otherwise. As the court knows, the incorporated city of Boston has unique zoning laws than any other town in Massachusetts. In 1991, hundreds of people, thousands of hours went into creating Article 51, the zoning guidelines. And this was an agreement between the mayor and the residents who participated in creating it. That is very, very unique. And I think that's something that should be emphasized within a Boston case. So my case is not against the owners. My case is against the city, whether they have the right to offer these variances or not. So the city has put forth no one of authority to contradict that they do have the right to this. There's no testimony from the city. So, you know, I have to say that I am defending, my position is against the city, not so much the owners. What is important about this zoning and this project and the house itself is that it's in a 1 family 3,000 zone as determined by Article 51.
Which is a different zone than your property is located in, is that correct?
Yes. I don't know historically from cases that I've researched, I don't think that matters. Whether they're, you know, it's how they affect each other. It's, again, that's my understanding. So, so this house was a 4-family, and it was converted to a 2-family with an office, so it could be turned back into a 4-family. So what I'm contending is that it's already well beyond 4 times larger than what the zoning allows. So the city would need to take that into consideration, that this is already beyond. There's already essentially been granted a variance. So if we allowed to pile up variances, we work our way up to a housing complex or a skyscraper, what have you. So again, I would say that the city hasn't provided any authority or testimony that they are allowed to grant these variances. In addition, rationalize that variances haven't already been granted to this property. So one of the questions is individualized harm. I obviously own the house across the street. I also do work at that house. I live in the neighborhood, and the individualized harm is by increasing the density in terms of population, in terms of cars, traffic, what have you. It makes it harder and harder for my property to exist as it is right now. Again, that's what these zoning laws were put into place for, is to protect all of the neighbors. As we know, the city of Boston has done a great deal of construction, is doing a great deal of construction. So although one project, you could say, has de minimis effect, ultimately, when you compile the 10 to 12,000 units that are currently under construction or have been made, the effect is much, much larger.
Are you talking about when you say it makes it more difficult for you? I guess I want to hear more about in what sense, for you to enjoy your property, or?
So the effect is, in terms of parking, it's harder for my residents to park. It's harder for me to park on the street. So when I have to do work there, with a larger number of people, it makes it harder and harder for me to park and do work there. It's harder for contractors to come and do work at my house. It's harder for my tenants. If it's harder for my tenants to come to park there, my rent is going to go down. It's going to affect, people's willingness to live there, because they can no longer park on the streets. In terms of enjoyment, absolutely. If you have a property across the street that's a much larger building, is getting closer to an apartment complex rather than a quaint house, now you have an effect in terms of both visual, the number of people coming and going. I enjoy it less, my tenants enjoy it less. So that is another aspect. I think there are other aspects in terms of, when you talk of population density, et cetera. Again, the effects on me are significant. The effects on my property are significant. The effects on my tenants, which thus affects the income on the property, are significant. And again, as you take this into a larger picture of all the other work that's going on, it becomes a very, very large effect. I don't see a timeline for timing for myself, so I don't know where my time is.
You don't see that clock?
Oh, I'm sorry. I'm sorry.
14 seconds.
I do see that. I'm sorry. What other questions do you have?
Well, we'll ask if we have any, but if you don't need to take all your time either. If you've told us what you need to tell us, I think we understand the facts of the case and the legal arguments pretty well. We've read, of course, briefs from both sides and heard now from you.
Okay, again, I think
one
my
question. I'm sorry, I do. Sorry, Mr. Porter, I have one question for you. There was a hearing on the motion to dismiss. Is that correct? Were you in court for that?
I forget what piece I was in court for, whether it was to dismiss or another portion of it. I believe there was a hearing for a motion for bond.
Okay.
That we might.
And we don't have a transcript for any of the proceedings relating to the motion to dismiss. Is that correct? In the record?
They would have come over from the Superior Court.
Well, you have to put them together in an appendix. For
okay. Us. Then it's not in the. If it's not in my appendix, no, then I didn't put it in there.
Actually, I think you designate transcript and it's sent that way. It doesn't physically go in the appendix.
So I'm set with my time. Thank you.
All right. Very good. Thank you very much. I know it's difficult to come before court when you're not a lawyer, so we appreciate you coming in and letting us know your arguments. Thank you very much. We will hear now from Attorney Singh.
Thank you, Your Honor. I'm representing the BOBBIE Family Limited Partnership, which is the owner of 599 Cambridge Street. The family partnership owns and operates a dental practice, or has operated in the past for more than 20 years. A family-owned neighborhood dental practice. And the principals are Nazila Bidabadi, who is the dentist, the chief dentist, as well as her husband, Ali Hakimi, who is the chief financial officer. It may be hard for Mr. Porter to make appropriate legal arguments, but my client should not pay because of that. My client is greatly suffering, and I'd like to start with what I was planning to end with, which is that it's appropriate and the court should award all of our attorney's fees and costs associated with this frivolous appeal. Very frivolous under the
Why do you say it's frivolous?
Because under both Murrow versus Esch Circus Arts, as well as Ricker versus Arahu, this is not property that's located directly across the street.
Well, I've looked at the map at page 57 of the appendix. It looks directly across the street to me.
Well, I would beg to differ, Your Honor.
If you continue the property line of your property in a straight line across the street, that line intersects the front property line of 604. If we're looking at that map, as Justice Hand suggested, that was not in the complaint. It's attached to an opposition to the motion to dismiss, although the judge took judicial notice of it. It seems clear to me you can have more than one property across the street from a property. That has to be. You could have a very wide property on one side, and a bunch of narrow ones on the other. Why isn't this directly across the street according to that map? I understand that Mr. Porter has not said it that way. He talks about overlapping lines or something easier to just say it's directly across the street, but isn't it directly across the street?
No, Your Honor. So if we could look at the language of section 11 of chapter 40A, and then I'll try to share my screen.
Sure, you don't have to share your screen. We have our the materials in front of us, so we can look at that map.
Yes,
if you'd like.
So I think the important thing is that if you look at the actual language of parties in interest as that is defined, it cites to owners of land, and land is singular, directly opposite on any public or private street or way. And so it does not cover multiple parcels of land.
Okay, well, now let's look at the map then.
Yes.
I see two parcels of land that are directly opposite and within, not just directly opposite, like totally within the direct oppositeness of your property.
Yes.
Do you agree that both of those are directly opposite?
We agree, and if either had appealed, we would.
Right. So your argument about it can only be one parcel of land is now gone, right?
Well,
that's two parcels of land directly across the street.
I don't. Thank you, Your Honor. I don't think it's gone. I think that the statute says land across the street. If one or both had appealed, we would be having a different discussion.
Okay. So explain why 604 isn't also directly across the street, because the entire property has to be within that line. Is that why?
Two reasons. One is the language in the parties in interest statute talks about land.
Yeah, but you've already said that there can be two parcels. So, all right.
Well, there appear to be two parcels. And the second reason is that the court also found, the Superior Court found that the property was kitty corner to 599. So there is.
Was that based on anything other than this document, this page?
Yes.
All right.
That's the information.
All right. So if it's clear error, it's clear error, right? It's not kitty corner. It would have to be. It would have to be further. I don't know where north is on this thing, but further to the left, I guess, to be kitty corner to something opposite. It looks like the property line, and I understand. I just don't know how we're supposed to say how much of the property has to be across the street. If 604 were almost completely across the street, but a little part of it went over, I think it'd still be directly opposite, wouldn't it?
I don't agree, Your Honor. I think that the way the statute is written, and granted, the statute does not apparently contemplate.
I don't know. This is a statute that allows abutters of abutters.
Yes.
Right. People a block and a half away, if they're within 300 feet, to have standing. It seems unlikely to me that we're supposed to read directly opposite in this weirdly narrow way where the entire parcel has to be directly opposite.
I don't think it's weirdly narrow, Your Honor. I think that's
compared to abutters.
Well, that's a judicial,
Right, that's far away.
That's a legislative determination. I
agree with that.
A butter to a butter, we wouldn't have that. But
yeah,
in any event, the other point, Your Honor, and referencing your concurrence in the Murrow versus Esch Circus Arts case,
yeah.
There's no particularized harm that's been alleged by Mr.
But he doesn't have to allege particularized harm if he's a person in interest. You have to rebut it with some evidence, which is why maybe this should have gone to summary judgment instead of being dismissed on the papers, right?
Well, I think that the court can acknowledge that if he is not a person directly across the street, right?
Yes, I agree. If
he is not,
but then we also don't need to talk about particularized harm. He doesn't even get in the door, right?
Well, but still,
I see. He could allege
argument that we need to. That's an argument that we need to knock out. That's an argument.
If he's directly opposite, then it's your burden to come forth not with an argument, but with some evidence. Now that might be easy. I have no idea, and of course, Mr. Porter is represented by a lawyer, so
right.
but.
So, Your Honor, I also think that the court can look at the matter holistically, if you will, essentially converting a motion to dismiss to a motion for summary judgment. Mr. Porter has had plenty.
He would have been given notice of that so he could get some discovery and maybe put some things in. I don't think we're going around converting.
Right, but Your Honor, under different facts as pled in his complaint, this complaint is generic.
The facts pled in his complaint are that he's in a butter.
Right, and that's inaccurate.
Right, okay.
He's not in a butter.
We have to take it as true on a motion to dismiss.
No, Your Honor, you can take judicial notice, right? He is not in a butter, as Justice Singh pointed out.
What am I taking judicial notice of?
Of the map, of the zoning map. Yes.
You think I can take judicial notice of the map?
Yes. Yes, and we have
because it's a zoning. So you want me to look at the map?
Yes, I think whether you look at the map or not. So first of all, you're judging this based on the complaint. Within the four corners of the complaint, you have learned that his allegations are false.
No, he says he's in a butter. How do I know that's not true?
Because you can take a look at what he submitted in his filings and see that he is not in a butter.
You mean by looking at the map?
Yes.
Okay, but you can plead the wrong legal theory in a complaint and it's still fine. A short, brief statement of facts. It says a butter, but he's across the street. You can understand particularly how a layperson might think someone across the street isn't a butter. You and I know that's not right, but
That's true. So what I'm asking the court to consider is that, sure, these are technical legal arguments that can be made, but I think we have to look at the record as a whole to reach a determination that is both consistent with the case law and promotes justice, fairness, and.
But you do agree that if we look at the map, we then have to decide, is this directly opposite or not?
Well, I've seen, and I don't have the case site handy, but I've seen, I believe appellate court decisions have basically looked at, on a motion to dismiss, have looked at these types of geographic questions and basically said, sorry. I mean, it would be one thing if there was something to this case, but there isn't. And I'd also like to just point out, since I have 5.5 minutes left.
Could I ask one question before you move on? At
Sure.
the motion to dismiss, when the judge was presented with, ultimately, with the Exhibit 1, the map that we're talking about at Appendix 57, was it your position at the time that the judge should take judicial notice of that or not?
Yes, Your Honor, that became an issue and we briefed it, both citing after. So we did have an argument. The transcript isn't part of the record, but we had a follow-up submission where we pointed out the Murrow versus Esch Circus Arts case.
But just so I'm clear, at that time, your client's position was that the judge should consider the map with respect to the directly across the street issue.
Yes, Your Honor. And just the point, because I don't think I would concede, but I could consider conceding if there was something that could possibly lead to a particularized claim of harm. The parking argument is frivolous. This is a busy dental practice that is in a building that has 2 commercial uses and
What
2
evidence
residential.
is there of that in the record?
Well, that's in our appendix, Your Honor. So we
What do
attached
you mean? Well, what is it in the record below?
it's in our appendix that, so the ZBA decision, Your Honor, we attached, it's supposed to be attached to Mr.
No,
Porter's.
we have the supplemental appendix.
Right, right. So it's very reasonable for the court to consider that the parking there is no parking impact. It's a much better parking situation based on the loss of a busy dental practice. So again,
Overnight parking might be, I don't know. How do we know?
well, Mr. Porter could have told us, but he didn't. Right. So that's the point. At a certain point, Mr. Porter is a party to 3 other appeals court litigations, okay, where there is a record
That's got nothing to do with this.
as there is, well, it goes to our request for fees under Mass Rule of Appellate Procedure 25, Your Honor. This court, the judge decided this case in December of 2018. It's been 2 years, full of procedural missteps by Mr. Porter. It's costing the BOBBIE family dearly. Okay. At a certain point, I would respectfully suggest to the court where there isn't a shred of evidence in the complaint, and it's an improperly pled complaint. You don't have to accept the fact that Mr. Porter says that he's in a butter when you can actually look at the materials that he has submitted and say, sorry, it's a complaint that should be dismissed. And so again, if there were a shred of something in there, there isn't. There is no particularized harm pled.
What is your best case for directly opposite requires the entire parcel to be directly opposite? Do you have a case for that?
Not right now, Your Honor. I was not able to find anything dealing with that question. Maybe that's the issue that's presented for, decision here, but I don't think that based on the facts as alleged in the complaint and based on the arguments that Mr. Porter has advanced, which are frivolous, that the court should stretch to find an interpretation of the statute, parties in interest, that gives him life. Could it be in another case that you decide not to foreclose that option? Sure, we don't have to decide all of those cases.
We're going to have the rule of law, so we're going to treat like cases alike. If the rule is completely opposite, then that's the rule, and if it isn't, then that's the rule, and we'll have to figure that out, I think.
So I don't think, just so the record's clear, I don't think that this is a property directly across the street, particularly where there are 2 properties directly across the street. And it's clear if you employ common definition to what it means to be directly across the street, and you ask an average person, they would not say that Mr. Porter's property is directly across the street. I understand your Honor has articulated a different understanding, but I would respectfully suggest that that's not what that language means.
But do you have a way to limit that? How much of the property has to be directly across the street? Because obviously there's going to be offset properties everywhere where where 80% of it is across the street.
Sure, I would say that where there are 2 parcels that are completely directly across the street from one end to the other, that's what it means to be direct.
What if there isn't? But anyone would say, of course, it's across the street because 90% of it is. But 10% isn't. Is that directly opposite or no?
Not based on these facts, no.
I asked you about my hypothetical. 90% is directly opposite, but there's 10% that's offset from it.
Oh. I think that it depends on where the other parcels were, but assuming that there were no other parcels, then that was the only property, I would consider conceding that point. But I think that's not the facts that we have presented here.
Okay. Seeing no further questions, your time has expired. It's a kind of interesting case, at least to me. Thank you both very much for your arguments. They're very helpful to us. The case is submitted. Thank you.
Thanks, Your Honor.